Bob Lambert's AssetProtectionTraining.com presents Ryan Fowler on Equity Stripping.
Hi, my name is Ryan Fowler and welcome to the AssetProtectionTraining.com video series. Today we're going to talk about part 3 of a series where we discuss how to protect your home. And this part of the series we're going to discuss equity stripping and how it can be used to protect your home and other assets. So let's get started. First of all, what is equity stripping? Well, equity stripping is a process of encumbering an asset with a lien or liens so that there is little or no equity remaining in that asset. This is particularly useful for protecting assets that cannot be moved outside the country or out of creditor reach, such as real estate and also LLCs, limited partnerships, very popular for asset protection, but they're not appropriate for owning a non-business asset such as a home. So we can equity strip that personal asset. Since a home's real estate and a personal asset, equity stripping is particularly useful. Equity stripping protects against both inside and outside liability. And what is inside and outside liability? Well, again, if you take a piece of real estate, let's say you put it into an LLC or a limited partnership, if someone sues you and you have an ownership in that company, that has this charging order protection, which we'll discuss in a later video. They cannot get the asset if they sue you. They cannot get the asset inside of that LLC or other entity. However, if someone gets injured on that property, and has a reason to sue because of that, that person can sue the owner of the property, which is the LLC. So if someone has cause to sue the LLC or limited partnership directly, that is inside liability. The other one was outside liability, and they can get the asset inside that LLC if they can sue it directly. However, with equity stripping, no matter who sues, there's no equity in the property. So inside liability, outside liability, doesn't matter. You're not protected. Whereas again, if you physically place the property in LLC or limited partnership, only protected against outside liability as far as that asset being protected. So liens are also enforced in the chronological order that they're placed on an asset. So if we have a $200,000 property and I put a first lien on there for $120,000 and a judgment creditor later comes along and gets a judgment lien, a second lien for $100,000, let's say they foreclose on the property and it sells in foreclosure for $150,000. Well, the first lien is going to be paid off first, so that $120,000 is paid off. There's $30,000 left over for the creditor. He doesn't get that first $120,000. Even though his lien's $100,000, he only gets what's left over after the senior lien holder has been paid off. Now let's say we take that same situation, but I put a lien for $200,000 on that property. If this second creditor forecloses on his lien, there's nothing left over for him. That effectively makes that asset worthless to him. He's not going to spend $2,000 to $4,000 to hold some type of foreclosure sale and not get any money for it. So that is effective asset protection. With that said, equity stripping, not all equity stripping programs are created equal. And so the definition of a lien is this is a definition in the Uniform Fraudulent Transfers Act, which is the body of law we're concerned in asset protection, because if they're going to undo what we do, this is the body of law they're going to look at. And this law says that a lien means charge against or interest in property to secure payment of a debt or performance of an obligation. So there's two types of liens, and it's really an economic right to property. That's what they mean by an interest in the property. Two types of liens. There's a debt-based lien, which is, to secure repayment of a loan, like a bank loan, and there's a mortgage on a home because of that. Then there's an obligation-based lien. Obligation-based liens aren't quite as well known, but they happen in the business world all the time, and they're every bit as valid as a debt-based lien. And there's a lot of things we can do with obligation-based liens. So if you're two businesses have a contractual relationship, they can each be obligated under that contract, and to secure that obligation, they can place a lien on some assets to make sure that obligation's secured. With that said, not all liens are created equal. There's some equity stripping programs very good, some are bad, and some are kind of in between. So let's discuss the different strategies that are used for equity stripping. So the first strategy, it works, it's just, it can be very expensive, and that is just a conventional bank loan. Let's say you have your home, it's free and clear, but you want to equity strip it, so you take out a bank loan, it's a $500,000 home, and you get a bank loan for $400,000, which maybe you can get that in today's environment, but maybe not. But let's just, for sake of argument, say that. Well, number one, you haven't equity stripped the whole asset, so that's one concern. But also, you took out this $400,000 loan, you have to do something to protect that cash, because the creditor can get that cash. So you have to protect the loan proceeds, but also you have to pay interest on that loan. And if you looked at home loans, a $400,000 loan, you may end up paying over the life of the loan $1.5 million in the process of paying that back. So it can be very expensive asset protection when you do the add in the interest payments and all of that. And what some planners say, and I've had asset protection planners where they actually recommend, hey, take out a bank loan. They can't do as much anymore because the lending environment is not as lax now as it used to be. But they say, take the money and invest it. And a lot of people did that, and then the stock market crashed, and they end up with a $500,000 loan on their home, and now their stock's only worth $200,000 or $250,000 or $300,000. And that's very high risk. We're trying to protect your assets, not expose you to a different type of risk. So I don't recommend that way to go. Another thing is when you do a conventional bank loan, your loan gets paid down over time. Gradually that loan gets paid off, which means more and more equity is exposed and that asset will become more and more valuable to the creditor. And so there is a better way to equity strip. Moving on to the next page, there is a plus side, and that is if a bank puts a lien on your home, no one's going to question and say, well, that's not a valid lien. That lien is going to stay on there, and a creditor, it's almost inconceivable that they'd ever be able to undo that bank loan. It's an arm's length transaction, it's an independent third party, lender's not an insider. There's something called the UFTA Section 8A defense, which means even if you took out a loan intentionally to protect that asset from a creditor, there's a third party involved that would be harmed if you undid that lien. The bank would be harmed if that lien was undone and the creditor was able to take the home. So that lien's not going to be undone, and that's Section 8A of the UFTA talks about that and says even if you do this to protect that asset against other creditors, we're not going to undo that even if you did it with fraudulent intent because you'll harm this third party. It's called the goodfaith transferee defense. Now, a concern though with these bank loans is you have to make regular payments on the loan. Now, if a creditor attacks you, you may be in a situation where all of your assets are tied up in LLCs or they're offshore or something to that effect, and it may be difficult. You may have problems making payments on your bank loan. Now, that's not always the case, and we do some planning to account for this contingency and make sure you're okay if you're sued by a creditor. But it's always a possibility that someone litigates against you, and even though more often than not this doesn't happen and we don't want it to happen, sometimes litigation can get really ugly and the creditor can pull out all the stops and it may impair your ability to repay a loan. It would be a shame to take out this bank loan to equity strip your property. A creditor attacks you, you're cash poor for a while, or you're not able to access your cash, you can't make the loan payment, and then your home gets foreclosed on. So the program you're trying to use to protect your asset ends up not working for that reason. So that's something that you need to think about. Now, with that said, it still might be worthwhile to do this because the lien will definitely not be undone. You can protect the proceeds. You can come up with a plan so you'll be able to continue making loan payments. It's possible. You may want to do this program anyways. If you wanted to take out a loan on your property anyways, for whatever reason, still may be a good idea to do this, but be aware of these potential pitfalls. Okay, now this, I really don't recommend doing this in any situation, which is just drafting up a mortgage or a deed of trust and then just filing it at the county recorder's office, and there's no reason for the lien maybe the lien holder's fictitious party, or maybe it's a friend or a relative or someone else. If there's no reason for the lien, it'll work if a creditor never challenges it. But if a creditor challenges it, he only has to show two things, and then these bogus liens will fall apart. Number one, he has to show that you're unable to pay your debts as they come due, and number two, he has to show that there's no real reason, there's no consideration, no one loaned you any money, you don't have any valid obligation, or there's no valid business context for having an obligation on this, or a lien on this property to secure an obligation. So they show that, fairly simple, and if they challenge it, don't be surprised if this lien falls apart, and you'll tick off a judge, because really you're engaging in somewhat of an act of deception. There's no real reason for the lien, you're just pretending there is. So that'll get you on a judge's bad side, and if you have other legitimate planning, he may just pierce through that planning because you've kind of showed him, that, well, maybe the other stuff is bogus too, even if it isn't. You'll get on his bad side, it can hurt the rest of your program. So word to the wise there for bogus liens, I don't recommend them. There is a program that some insurance and asset protection specialists push. It's called accounts receivable factoring. What happens is someone loans you, a third party loans you some money. They put a lien on your accounts receivable to secure that debt. And then you're supposed to take that money and invest it in an annuity or life insurance. And the theory goes that because annuities and life insurance are exempt from creditors under state law, then it works great because they can't attach the annuity or life insurance. There's a lien on your accounts receivable, so no one can touch your accounts receivable. Works great. Well, there's at least that's the claim. There are some pitfalls with that. Number one, only about half the states offer meaningful amounts of protection, if any protection, on life insurance, and even less on annuities. So you may not live in a state that offers good protection, and even if the statute makes it seem like the life insurance is protected, a lot of these exemptions, these statutory exemptions, they have loopholes in them. They have ways where a creditor may get around that protection. You may have to, for example, there's some statutes that say if there's a clause in the life insurance policy that says this policy, the proceeds are protected from creditors, then it's protected by state law. And guess what? Most policies don't have that language in the policy. If that's not in the policy in your state, if that's what the law says in your state, guess what? That policy is not protected. A creditor is going to grab it. So those all sorts of little idiosyncrasies and exceptions to these laws protecting life insurance. You got to be really careful. I'm not saying your life insurance won't be protected, but be careful. And the problem is the people that are pushing this usually they're not hardcore asset protection experts. They may just be an insurance salesman trying to sell you life insurance, and they come up with this program because you're going to get a loan from a third party and then you're going to buy their life insurance. And they really don't know how this works or whether it works from an asset protection perspective, and there could be just big loopholes in your program. Another thing, if you buy a variable universal life policy, variable universal annuity, or some type of life or annuity product that goes up or down according to the performance of your investments, well, the market can tank again, and then you're in a situation, again, like where you take a bank loan out and you're hoping you invest it and you hope it to exceed the amount of interest you're paying on the loan. Same thing here. You can end up, you take out the loan, you lose money, and now you're in a really bad situation. So with that said, this might still be an okay way to go. There's just a lot of areas where I'm saying here's a potential pitfall here. Be very cautious. Instead of equity stripping your accounts receivable with a debt-based lien, you might want to equity strip it with an obligation-based lien, which we'll talk about shortly. You can also do what's called a billing and collections company, which I'll talk about in a separate video. So just be careful if you're going to do accounts receivable factoring to equity strip your AR. So let's talk about the friendly loan. This is different from a friendly lien because, or a bogus friendly lien, because it's not bogus. It's actually someone giving you a loan. And this can be a pretty good way to go, although there's still a little bit of caution in some areas. If you have a friendly party loans money to you, he can structure the loan, for example, he can structure it so that you make a balloon payment. You just pay annual interest payments and then make a balloon payment in 10 or 20 years. That way the loan doesn't get paid down and the full amount of the lien stays on there. In addition to a balloon payment, if a creditor attacks you, he can be lenient towards you if you're unable to repay the loan, and he won't foreclose, and he'll wait until the creditor threat is passed, and then you can make it up to him or something like that. Hopefully he's a trustworthy person that'll do that, because he will have a lien on your asset. And in addition to that, you do want to check with tax counsel, because depending on how this arrangement is structured, this may or may not be, the interest payments on the loan may or may not be tax deductible. And if you're doing some type of arrangement where you're making loan payments to this guy, and then kind of on the back end he gets the interest payments you'd normally lose to him, he's getting that to you in a roundabout way, just be careful, because that could actually weaken the program if they find out money's coming back to you from this, you're making loan payments to this guy and he gets the interest payments back to you. Just be careful with that. It could be a tax trap there too. Best case scenario is the person's just a friend and is not considered an insider. A friend could be an insider under fraudulent transfer law, but that's a lot more difficult to establish. A relative or a very close business associate is more likely to be seen as an insider. Doesn't mean the loan won't work, but it means the loan, instead of a strong loan, will be considered a medium strength loan if the person that loans it to you is an insider. And also make sure you make payments on the loan at least annual, at least interest, at least once a year, so it's going to be considered a valid loan by a judge. And make sure, of course, you get the money, and then you protect the money so that when someone sues you, they can't get the loan proceeds. So another way to go is using a line of credit to equity strip your property. If you have a home, let's say you get a line of credit on it, they're going to put let's say $1 million home, put a line of credit on it for $500,000. The bank will put a lien on your home for $500,000. Now, that lien may not be effective if you get sued and you never use the line of credit, no money's out, you don't owe the bank anything, so the judge may let the second or third in line lien holder just foreclose, and to the extent you haven't used the line of credit, they can get anything. So when you get sued, you need to use the line of credit. The good news is, unlike a regular bank loan, you're not going to be paying a ton of money towards interest payments all the time. You only pay it when you know you're going to need to take out the line of credit, either because you want to or because you have a creditor threat coming down the line. Now, when you take that money out, you need to take it out at the very first sign of creditor trouble. There's a little bit of risk, fraudulent transfer risk, when you do that, and so you might need to take the money offshore or put it into some type of exempt policy. If you put it in a life insurance policy, might work, but the cautions I told you about before still apply. Maybe you take it offshore and buy foreign insurance, and so it's not only offshore, but it's a foreign insurance exempt under that country's laws. Then you get that Section 8A defense of the UFTA, even if they say it was a fraudulent transfer. You say, well, this third-party life insurance company, you can't undo the contract. That will hurt them. And, besides it's an offshore trust or offshore LLC, that's better than just taking the money offshore by itself. And so, with that said, if you take the line of credit out and try and protect that money after a creditor threat has already arisen, they're not going to undo the lien. But there's at least a little bit of risk there with the proceeds that you're trying to protect. You'll probably be okay, but you really need to kind of take it on a case-by-case basis, depending on the size of the threat and the size of the asset you're trying to protect. May or may not be a good way to go, but usually it's decent, and usually it's pretty strong to protect this way. Now let's talk about obligation-based liens. The good thing about an obligation-based lien is, when you do debt-based liens, you have to worry about interest payments. Either, if you're just repaying principal, someone gives you $400,000 and you give them $400,000 back, no big deal, but now you're giving them interest payments back. What are the income tax consequences of that? And also, that's, money that you're losing. And so, obligation-based liens, you don't have to mess with any of that. You don't have to worry about the tax aspects, and you don't have to worry about losing money to interest payments. So depending on how you do an obligation-based lien, it can be a medium strength or it can be very strong. It all depends on how it's set up. There are many different types of obligation-based liens. I talked earlier about how contractual obligations, and the PowerPoint talks about that. Let me tell you about a landlord's lien. This happens in the business world all the time with commercial office space being leased out. I used to review commercial lease agreements all the time because I was running some corporations. I was a secretary on several corporations. And when we rented out office space, there would be this lease contract, and they would have a landlord's lien in most of the contracts I read. And what it says is it says you need to honor this contract, and we're going to put a lien on the assets of your company that's renting out this office space, and if you don't honor the contract, we have the right to take those assets we've placed a lien on. Now, in this arrangement, normal arrangement in the business world, the landlord hasn't loaned you any money. They've just given you the right to use the property for a period of 3 years, a 3-year lease agreement. And you don't only have to make rent payments, but you have to make rent payments. You have to honor all the other terms of the contract, which is maybe you have to take care of the common areas, keep the place in good repair, only use it for a specified purpose, not maybe there's a clause saying you cannot sublease the property. Whatever terms, you have to honor those terms. And so that's a valid lien, it's a valid obligation. That's something that happens in the real world. Now, you can do something like that maybe, or just any other contractual obligation that's a legitimate obligation, a legitimate business context. We can come up with that and draft up the contract and place a lien and do that to equity strip your property, a home or rental property or anything else. Even if the other party that is the other party to this contract, even if that person's an insider, that doesn't mean it's a bad program, but it takes it from a strong program to kind of a medium strength program. And again, insider is usually seen as a very close business associate. When I mean business associate, it could be a partner or someone else that controls the company with you or a relative. And so we'll move on to the next slide now. Let's talk about obligation-based lien I use from time to time, equity stripping via LLC capitalization. Again, moderate to strong depending on how you do it. What happens is 2 or more parties form a LLC, limited partnership, or LLP. Let's just say LLC from now on. And this LLC is going to have some type of business purpose. Maybe it's an existing company. We'll form a new company or existing company. If you're able to obligate yourself to render services to that LLC, well, you have another partner that is vested in the company as well, and he wants to make sure you make good on your obligation to the company because he's vested in that company. And you could say, for example, that, okay, I'm obligated to render these services to the company, and I actually get a bigger share of the profits in the company because of that obligation. And my partner wants to make sure I make good on my obligation because he's vested in this company too. So the LLC places a lien on my assets to secure my obligation. Now, as long as the LLC is adequately capitalized, it engages in some type of legitimate business activity. Maybe that activity is just trading stocks, buying and selling. If it is trading stocks, you better actually be doing some active trading. Don't just buy a bunch of stocks and hold it and never trade it. But that's one thing some people can do, or any other business activity. You can use this arrangement to equity strip your home. And again, same thing about is the other partner insider, etc., that may make the program a little weaker if you don't capitalize it enough, if it's not like maybe it's a business activity but not a really strong one. Again, that can weaken the program. But there is a place for these programs that are medium strength instead of really strong, and we'll talk about that. Next slide, please. Yeah. And this is the best use for medium strength programs. I already talked what they are. Let's say you have a property that your home is worth $1 million and has a $600,000, $700,000 loan on it. Well, I would equity strip that even if you can only do a medium strength equity stripping program. And the reason for that is that first 60-70% of equity in the home is the most valuable equity to a creditor, and it's already covered by your mortgage. Why is it the most valuable equity? Well, if someone forecloses, they'll probably get 60 to 85% of the home's value in foreclosure. In this market, I'm thinking 50, 70%, 85%, probably not in this current real estate market. So if that first 60% of equity is covered by a mortgage, it's already protected. A creditor, the lien we put on there is not going to be as something they have as big an incentive to go after, because if they get rid of our lien, they still have the first lien that's attached to all your valuable equity, and if they foreclose, they'll still get little or nothing. But remember, I told you earlier, if you have a normal bank loan on your property, that will get paid down over time, and eventually you're going to have a lot of equity exposed in that property. Well, put our medium strength lien on now, and after 4 years of that lien being on there under fraudulent transfer law, the statute of limitations for in most states, statute of limitations for challenging that lien expires after 4 years. So by the time the more valuable equity becomes exposed because you pay down this first loan, our equity stripping program, statute of limitation has expired. It goes from medium strength to a strong lien that will be very difficult for a creditor to undo. And we make it big enough so that as your other loans paid down, it still attaches to all the equity's gone. And so by the time your first lien's paid off or paid down enough to where the asset becomes attractive to the creditor, you have this other lien that's changed from a medium lien to a strong lien, and that is a really good, strong asset protection program. So to wrap up, that's quite a mouthful, a lot of food for thought regarding equity stripping for you. There are other ways to protect your home. So equity stripping, it works great for some people, it's not for everyone. There's also non-qualified personal residence trust, or even tenants by the entirety ownership. There's other tools we have, but this is how you do equity stripping, and I hope you find this information useful. Thanks.